Hi, everyone. Welcome to this week's weekly live immigration attorney chat here at Immigration for Couples. I'm attorney Megan Pastrana. And for those of you who are new to our channel and to our law firm, welcome. We're excited to have you here. For those of you who have been joining us every week for a long time, welcome back. It's great to see you. Good morning to you as well, Anna. It's great to have you with us. And I know you have a question I saw that I don't believe I got to answer last time. So I'm glad you're here and I'm happy to answer that question here today. All right. And so if you're new, we do these weekly live immigration attorney chats because we know here in Immigration for Couples, knowledge is power. And the immigration journey, it is a labyrinth. And I like to joke that it's a little bit of an alphabet soup and it can be a bit overwhelming for couples when you're just starting out because there are K1 visas and there's AOS and there's CR1 and IR1, and it can just feel a bit much because immigration law is a very complex area of law, and the immigration process, by its very nature, it's very bureaucratic and it has a lot of steps, and the policies and procedures are always evolving and changing. And that is why our firm focuses exclusively on this niche area of immigration, specifically for couples and their families, so we can always be on top of and stay apprised of all of the details and changes that are happening in the world of couple-based and family-based immigration. I have created, my team and I rather, we've created a free resource center, and you'll see that below at immigrationforcouples.com. And that free resource center, along with these live chats, we've gotten a lot of great feedback from viewers saying that it's just been extremely helpful. And this free resource center is very robust. It has a free webinar that I created that really goes into, if you're just starting out, it's a great webinar to watch. It goes over the different options that are available to you when you are starting out, what the eligibility requirements are, how to pick a path, how to prove your relationship, and how to not just survive, but thrive in your immigration journey. And there's also a free relationship evidence guide. So I'll leave that below for all of you to reference. And if you could let me know, one of my favorite things to do is have all of you tell me, where are you at in the world? So, if you're in the United States, let me know what city and state. If you're in another country, where are you at in the world? My team and I, we love our work in the world because we love and helping couples, but we also really enjoy getting to work with individuals all over the world. So tell me, where are you at right now? All right. And Betty Ann, it's great to have you back. You're in Canada. Awesome. So let me just go ahead and dive in with the very first question that I have. So Medusar, I hope I'm pronouncing your name correctly. You're asking about tax documentation, and is tax filing documents, are they mandatory for the affidavit of support? Because the petitioner, you're saying, his income coming from Social Security, that's not taxable, and that's why he is not filing taxes. So the affidavit of support, for those of you who are, just starting out in your journey or haven't gotten to that part of the process, I'd like to explain what the affidavit of support is. I always like to give a 30,000-foot view for context so we can all, learn and benefit from each other's questions. So the affidavit of support is a required part of the immigration process for anyone who is applying for a green card. And it is a requirement because as the immigrant beneficiary who's receiving a green card or lawful permanent resident status in the US, you have to show that you won't be a public charge. That is done through something called the Affidavit of Support. The Affidavit of Support is a form, it's more than a form, it's a contract with the US government where you as the petitioner are saying that you will provide financial support for your spouse or fiance who is receiving a green card, because he or she is not eligible to receive government benefits. And so the government wants to see that you will provide financial support for this individual. And it's important to know, a lot of individuals are surprised to find out that affidavit of support, that contract, that obligation, that document that you are signing, it actually continues to be your responsibility, even in the event of a divorce. Heaven forbid, we don't want that to happen, but it's important to, I'd be remiss if I didn't share that fact. And also, you will be required to be the financial sponsor until that individual becomes a US citizen. So oftentimes, the path is ultimately wanting to have US citizenship. And so at that point, that affidavit of support contract would no longer be a requirement. But I wanted to point that out to give everybody a little bit more education on the affidavit of support. And so with the affidavit of support, you do have to not only provide your total income for the prior year, but you have to provide financial documentation. So typically that will be tax returns. So for individuals who receive non-taxable income, often you're not going to be filing a tax return. Sometimes that income can still be used to show that you meet the poverty guidelines that are set out by immigration. But often if there isn't a tax return, and if there's not enough proof, if you don't meet that basic income guidance requirement from immigration, the I-864P is what that's called, then you would have to move into assets. So there you would need to include proof of the Social Security income. If that's not enough, then you would want to look at assets. With Social Security income, that can be a little it can be a little tricky because it will depend how much the individual is making, and it also is going to depend the basis for receiving that income and if the individual has other assets outside of that. So if there's any kind of other income through maybe some kind of pension or something like that, or some kind of, if there was a retirement or things of that nature, probably not. I mean, I don't have all the details of your particular situation, but in general, tax returns are required. If you don't have them, then you will have to provide proof of that income. Depending on that type of income, it will determine whether or not immigration will accept that. And then often what we would do would be look at assets. So things like a home or money in a savings account or an investment account to see if that individual has enough in assets to make up the fact that they don't have enough in income. And then if there aren't enough assets, then you would move on to having a joint sponsor for the case. So that's kind of usually the path that we take when we're looking at an individual situation like this, where they don't have a tax return. We need to see what is that income that they are receiving, how much is it, why is it being received, when did they start receiving it, to determine whether or not it will be okay to just use that income and possibly assets. So complex, it's a complex question, and I can't give any more specific advice without knowing more details. And I'm always happy to speak with you during a consultation. So that phone number is below. You can call the office at 317-247-5040, and someone from my team would be happy to get you on my calendar. Alternatively, you can schedule 24/7 on the website immigrationforcouples.com. All right. A great question to start out with. A little bit more complex. All right. Anna, I know you had a question. I wanted to see if you threw it back in there. There you go. Thank you. But yeah, because I know I'm going a little bit out of order because Anna was here last time and she had a question, and the time that I had allotted, I wasn't able to get to it. So I wanted to go ahead and pull yours out of the queue here since you had asked it last time. Do we need to send, so you're asking for removal of conditions. I don't know if this was your same question or not, hopefully. But you're asking on removal of conditions, what do we need to send exactly from tax returns? Do we need to print everything or just the transcripts? Tax transcripts are nice. Make sure you're getting the account transcript. Or if you filed a 1040, you'd want to file the 1040 and any schedules and forms that would accompany that, be it 1099s or W-2s. So, but yeah, tax return account transcripts are nice. That can work for sure. All right. So who is next in the queue? Okay. So U.S. Embassy in Pakistan didn't mention about joint sponsor for K-1 visa on the website. According to my research, some countries are accepting joint sponsors and some are not. Please guide about Pakistan. So for the K-1 visa, just like spouse visas, any case that the ultimate goal is to receive a green card, you have to have that affidavit of support. So that was that very first question that I was discussing. Joint sponsors. There are not countries that don't accept joint sponsors. It's just a matter of, is that particular immigration officer going to accept that joint sponsor's income? The affidavit of support is one of the most complex parts of the immigration case because you are dealing with finances and tax returns and current annual income and if it's projected to continue on that path. If the petitioner doesn't make enough, then immigration can be picky. They are picky with the affidavit of support because it is more than just a form. It's a contract with the government. They want to see that this person who is signing the contract is able, capable, has the income to take on this responsibility of being the financial provider for this individual should he or she be unable to work. So it's not true that some countries aren't accepting joint sponsors. Some countries, because each U.S. embassy and consulate has, a different supervising officer and a different team of officers, and each country, even though it's all U.S. immigration, each office has its own flavor of what they consider their policies and what they look at in terms of standards for joint sponsorship. So immigration rules about the affidavit of support and the documentation that is acceptable, that's standard, that's in a policy manual. But the reality is there's just so many nuances that each U.S. embassy and consulate might have their own way of interpreting or viewing the affidavit of support. And some embassies or consulates insist on having tax transcripts, while others only want the 1040 forms with the accompanying W-2s. So we always, send our clients with both, but some embassies will say, nope, we just want you to come with the tax transcript. So it is important to make sure you educate yourself on that specific post. So joint sponsor needs to be eligible to fill that role. A U.S. Immigration officer will deny a joint sponsorship application if, for example, the petitioner does make enough. So I've seen some individuals where a petitioner says, well, can I just get a joint sponsor and not have to provide my taxes? But it doesn't work that way. If you as the petitioner make enough, you have to be the sponsor for the case, and you do have to provide your financial information. I'm not saying that that's your situation. I'm just giving an example. And then the next, like I had said with that very first question I received, then the next step would be, if for some reason the petitioner doesn't make enough, does the petitioner have enough assets? We always like to go there next in our analysis. And when we are setting a case strategy for the couples that we're working with, we like to look at assets next. If there's enough assets, then we can avoid the whole joint sponsor piece of the equation. If there aren't enough assets, then yes, you do need to have a joint sponsor, and he or she must qualify. So you'll want to make sure that their tax returns reflect a current annual income that is above poverty guidelines. And you'll also want to make sure that that individual still has that same position and is on track to be making that same amount in the next year. So you'll have to provide all of that documentation to ensure that the embassy would accept that joint sponsor. Okay. So I know you're probably seeing, yes, the affidavit of support is a complex beast. And as always, you're welcome to schedule a consultation, a one-on-one consultation with me using the information below, immigrationforcouples.com, or by calling the office. All right. Let me toggle over here to Insta, because for some reason, the platform I'm using, I'm streaming here on Facebook, LinkedIn, YouTube, and Instagram. And so I see everybody's questions in order, but Instagram just does not come through. I see them. I do see your questions on Instagram, so I'm not ignoring you. I just want you to know I have to toggle over every once in a while. So yeah, we have someone here, an Angela from the Philippines. Great to have you with us. I have a question that's asking about, let's see, you're Canadian and your fiance is American and you're planning to marry next summer in Canada. Congratulations. That's very exciting. And if we apply for a spousal visa after a wedding, would I no longer be able to travel back and forth? I think that this question is probably the most popular question I receive. There's a lot of popular questions, but this one, I seem to be having individuals asking me this almost every week. And I know why, because there's a lot of conflicting information and rumors out there. So the question is essentially this: if you have a pending fiance or spouse visa case, are you legally able to come and go, to come to the US and visit? So for individuals who have ESTA or a tourist visa, or for our Canadian clients, you don't have to have that. You're essentially a tourist when you come and visit the States. But legally, the answer is legally, yes. If you have authorization to travel into the United States for a visit, you can still come for a temporary visit. Understand, though, that when you are coming to the United States, every time you're coming into the United States, immigration officers are going to look at your entry and are going to look at your specific situation to determine whether or not they think your intention is that of a non immigrant. So that means that they want to see that all of the circumstances, everything surrounding your entry supports the fact that you are just coming for a tourism short visit. So when you have a fiance or spouse visa case pending, that is immigrant intent. That means that you have filed with immigration with your fiance or spouse, and you have immigrant intent to come and live in the United States. So you can see how that can be a bit conflicting, right? That you're coming for a visit, but you do have this immigrant intent. And so sometimes that can present some obstacles for you upon entry as to how immigration is going to view that entry. But the important thing is being honest with immigration that you are just coming for a short visit. For those of you who are flying into the United States, making sure you have that round trip ticket with a departure that's well before the ESTA or tourist visa end date, so 90 days or 6 months, making sure you just have that short trip, proof of that return. If you have a job and obligations in your home country, it's good to have proof of that as well. Anything that pulls you back to your home and to your country outside of the United States that further supports that you're just coming for a visit. So the short answer is yes, technically, legally, you are able to enter if you have that intent for just a short visit. The reality is that you could face some obstacles, some difficult questions, things of that nature when you're entering the United States. And that immigration officer can ultimately decide, we don't really think that you are coming here just for a short visit. You do have this application pending. We're going to send you home, and you need to wait abroad until your visa for the fiance or spouse visa is approved. But we do have couples who travel all the time, and we support them and help them to make sure they're prepared for each entry to the United States to give them the highest likelihood of success in being able to visit. So we do have couples that do that all the time. So great question. I hope that was helpful for all of you. I wanted to go a little bit more in depth because that seems to be a reoccurring question. And then you are also asking, does the spouse visa process generally go more smoothly if you're Canadian and my fiance is American? I'm planning to move to the US after my wedding next summer. So you won't be able to officially move to the United States until you have your, you said, yeah, you're doing the spouse visa. Because I saw the word fiance and I want to make sure I read it right. You can't officially relocate, move to the United States until you have that spouse visa in your hand. The spouse visa is essentially your permanent resident status, your green card. That only then are you allowed to pack all your bags and relocate and live in the United States. So if you're getting married next summer, you would be filing for the spouse visa. After that, it's important to understand that current wait times are about a year and a half, 18 months to get through the spouse visa. So you'd have to wait and go through that process until you got to the end and received that spouse visa to enter the United States. I really encourage you, the individual who's asked both of these questions, that you check out the free resource center on my website, immigrationforcouples.com, and then you start out looking at the webinar that we have. And also there's a lot of resources about the fiance and spouse visa. And I'd really encourage you to schedule a call with me. Let's get on a call and speak in private about your specific situation, because I'd really like to see you consider the fiance visa as a possibility. And maybe you've already ruled that out. Maybe you already have your reasons, and that's completely fine. But if you're wanting to relocate to the United States after your, next summer, I know you already have your wedding, the plans in the works, but I'd really like to see you considering that as an option, because that's something we can potentially, file sooner and might be more in alignment with your timeline. So I'd be happy, like I said, to speak with you in private. You can book that appointment with me on the website, or at a minimum, check out our free resource center. But great questions. Those were very helpful questions, I think, for anybody who's watching here on the live. So those are common questions. All right. We have a lot of individuals joining us live. This is fantastic. Keep the questions coming. If I can't get to them, I will, like I did with Anna's questions, start with those next week. Okay, so Sheila, you're wanting to know how long do they keep your records from trying and getting denied previously? We were told 2 years and that they dispose of them. That is really interesting that you heard that as that rumor. Immigration keeps records forever, forever. There's no disposing of any prior records. I regularly, my team and I order immigration records for our clients. We do that for anyone who has any kind of immigration history because we want to have the whole picture. We never want to go into our advocacy blind. And I have been able to obtain records from the 60s, from the 70s, from the 80s. I mean, record keeping has gotten better. So some of the older records sometimes are a little bit more difficult to hunt down, but there are different parts of the immigration system. So there's an Office of Biometrics and Identity Management. That's one part of immigration. They keep your biometrics. So fingerprints, anytime you've ever had contact with immigration and they've taken your photo or your fingerprints, so like entries to the United States, things of that nature, they have all of that. USCIS, they have your complete what they call A file or alien file, all of those records. Consular offices, US embassies and consulates, that you can order those records as well. So no, that sadly, well, I shouldn't say sadly. Immigration is actually is organized and does keep all of those records. The reason I was saying sadly is because there are individuals who think that after a certain amount of time, immigration won't have those records or they wouldn't have access to it. And then they go to their interview and there was this prior denial or there was this prior issue in their immigration history that maybe they had forgotten about or didn't know was an issue. And sadly, then they receive a denial and then have to go through a waiver process. So that's a long answer to say they keep everything. If you have prior denials in your record, if you have a case that's more complicated in its immigration history, then you definitely want to speak with an immigration attorney who can help you to order those records, understand the implications of these prior denials. Are there ways to overcome those issues through submitting a really strong case, or is a waiver required? So yes, those records, that file, that will be there forever. It doesn't go away. All right. Let's see who I have next here. So, Clara, nice to have you with us. You married. If you married a United States citizen and we apply for a spouse visa while I'm outside the United States, would I be able to come and visit? Oh, so great. Hopefully, Clara, you are here for the question that I had from Instagram because that long answer is exactly the same. Yes, it's possible, but every entry is discretionary and immigration could decide to not let you in. So great. See, I told you that was that's a very popular question. We had 2 of those today. So I am having a great week. I hope you are too. Yeah, Betty Ann, great question. Yes. After you're documentarily qualified, you still have to prove your relationship again and again and again ad nauseum. So we tell our couples all the time after we submit the first step, keep saving your relationship evidence because after you are documentarily qualified, you have to prove your relationship again at the interview. If you receive a 2-year green card, then you're going to have to go through removal of conditions and approve your relationship again. If you file citizenship at the 3-year mark, you have to prove your relationship again. So keep saving your relationship evidence. For couples who are in love, that comes very natural. It's a very organic thing. You'll be taking photos and doing all the things that couples in love do. And then, paying attention though, after you do have your green card, once you're both living in the same place, being very intentional about filing tax returns together and having your joint bank account that's actually active and being used. So yes, absolutely. How do you submit a statement oh, I should pull it up so everybody can read it. So how do you submit a statement for an unattainable document? The only way to obtain said document is in person in Russia. I believe you had asked, not this question, but you were talking about, I think, a police clearance or something of that nature that was not going to be possible to obtain. I think that's what it was. So it'll depend on the type of document, how you will submit that statement of being unattainable. Sometimes the unattainable statement is something you have to get from the government itself. So, like a government entity, for example. The one that comes to mind for me as an example for you is that the US Embassy, the US Consulate, rather, in Ciudad Juarez in Mexico, they have a really unique requirement of wanting a long form birth certificate for the petitioner. There's a lot of US embassies and consulates that ask for the long form birth certificate too. But sometimes in certain states like Indiana, a lot of states in the United States, you aren't able to obtain that long form birth certificate if there was a prior name change in the past. So if there was an adoption or a legal name change that happened, they won't be able to issue you a long form birth certificate. So actually, the state, the vital records office of that state will provide you a letter that says this document is not attainable. And so immigration will only accept that document from the government entity or from that entity that the document's not attainable. So you couldn't just like write a statement and say it's not available. They'll say, get that from the entity where you're supposed to obtain the document. We need to hear it from them. So sometimes it's a matter of having to get it directly from that, that entity. So that is something you will want to look into. In some situations, there are country conditions and resources and research that we can do. And my office would put together essentially a legal brief and explain, look, my client did X, Y, and Z in good faith to obtain these things. And then, here's the supporting research. It's not available. And then we'd have them, also the client provide a statement of what they did and sign it. So there's not really a set standard for or procedure for the unattainable document. It's really just going to depend on the specific document. And, is there a document that you can obtain from the government that explains it's not available? Otherwise, then you would have to do something a little bit more formal in writing and checking with the consular post as well as to what they would accept. And if all else fails, if you are needing legal help, we are here. You are welcome to schedule a consultation to engage our services. But good luck to you. I would start by asking the government entity if they have something that shows non-attainable, and then also checking with the U.S. Embassy or consulate where the interview will occur to confirm, what they would accept. So, all right. So, and so we have a lot of individuals telling me where they're at. I love to see that. So you're in the United States and your wife is in South Africa. That's awesome. We have a lot of clients in South Africa. Orlando, be safe. That hurricane that's coming through, hopefully it fizzles out while it starts to get more central and more through central Florida. But please stay safe. Hopefully you have all of your provisions and you're ready. Czech Republic. Oh, Claire, that's awesome. Great to have you with us. So Wichita, Kansas. Oh, we have 2 Wichita, Kansas. That's fun. Okay, Mission, Texas. Seattle, great to have you with us. Atlanta, Georgia. Philadelphia. Awesome sauce. Oregon. Okay, great. Well, let me see who we have next here in the queue with questions. I don't want to skip anybody. Oh, there's the next one. So you're wanting news about the parole program, the family unity program, the Biden administration program that was announced for individuals who've been here for more than 10 years and married to a United States citizen. This is such a great program. I know there are a lot of opposing views, and that's fine. We can hold dualities here and hold everyone's opinions as valid. But my opinion is that it was a really great program, a really great opportunity for couples to be able to go through this immigration process in less time and have their family have unity and stability faster. Currently, the program is in essentially there was a pause button hit by the federal court, district court judge, and the program is paused. We are waiting on hearings and for them to make a decision about whether or not they believe that the program was legally created, that there's a legal basis for the program. So right now it's still on pause. Immigration is still accepting applications for the program. They just are not allowed to legally adjudicate them or make a decision. We're hoping to hear some more updates soon in October. And yeah, that's what we're hoping to hear more updates, but it is currently paused. If you were eligible for that program, if you didn't file an application, if you didn't have an opportunity to get that application filed, please know you still likely have options, and we are still helping couples go through the standard process. There are steps that we can take now to still get you one day closer to the green card, even though that program is paused. There's still a path. It's the longer path of the petition and filing a waiver of forgiveness, but taking the steps to file that petition and taking the proactive steps that you can take right now to put you in the best position. And then if that program is reactivated, then you could file that application, and you can still use the petition and a lot of the steps that we can take now to put you in the best position possible. But hoping and praying for good news that program can be revived soon. All right. Okay. So good afternoon, and you're from Nigeria. It's great to have you with us. Michael, thank you for being with us. And let me see, if you have a question, you're welcome to throw that in. Hi to you as well. Manya, hopefully I'm Kumar. I hope I'm pronouncing your first name properly. You're living in India, and my husband is a US citizen. He applied for a spouse visa. And in April, he got the letter, notice of action, that USCIS has received the application. Well, congratulations. That's good. You are in the queue, and you are one day closer. So sending you prayers and positive vibes that you get a decision soon. Hi to you as well. Oh, and Manya, it looks like you had a follow-up question on that. So how long will it take to get another letter for biometrics? Still waiting. Can you please tell me? So if you are both living in India and you're going through the spouse visa process and you filed that initial petition, biometrics won't actually happen until you're closer to the actual interview scheduling. They don't send you a separate notice for biometrics. For individuals who are living in the States and file that petition, biometrics is something that you have to do in the US. But if you're abroad, that happens with the interview. It won't be a separate notice. All right. So your husband is United States, and he sends me money sometimes on my mother's ID card, Western Union. Can you use that as evidence of financial support or not? So ideally, you'd want to see the money transfer going directly to you. If it's going to your mother, it could still possibly be used. Typically, if that is the case, though, we want to look at other evidence and see what other evidence you have. Typically, if you have evidence that isn't clear, like that money transfer clearly going directly to you, that could cause issues in your case. And so without seeing all of your evidence, I can't say conclusively yes or no to include it. But in general, it's not a great idea to submit evidence like that. I'd really encourage you to check out the free resources center on immigrationforcouples.com. And I have a very robust relationship evidence guide that you can check out and look at other categories of evidence. I'm sure you have many other different types of evidence that you could use that would be stronger than that. All right. So Chris from Nigeria, great to have you with us, Chris. Ginger, good morning to you as well. And I know you're with your fiance in Tennessee, so that's exciting. All right. Okay. Anna, this was the question I remember. You asked for letters of support from family and friends. Does USCIS require specific font style and size? So not font style and size, but you will want to look at the USCIS instructions. They're very long about what they require for those letters of support. They aren't particularly concerned with font style and size, but you want letters of support to convey details about your relationship. You don't want the letters to all look the same. You don't want them to be saying the same things. And sometimes you need to also be careful that the letters aren't so similar in format that it looks like you drafted them, because that can be considered a red flag. In immigration, I've definitely talked with immigration officers who've said, yeah, all the letters of support were formatted exactly the same. That's a red flag. That looks like you as the applicant drafted those letters. And I know sometimes that's not the case. Sometimes family members work together and it's not really a red flag, but immigration can see it that way. So I would say make sure those letters are unique and have details that only that person would really know about your relationship. I would want to see you asking individuals who have spent time with both of you, who know both of you, um, and can really attest to their, personal witnessing of your union and your relationship and love. And yeah, and making sure that I'm sure you will. I know you're very meticulous. You're very meticulous in your questions, and I know you're taking this removal of conditions process very seriously. So I know that you will be diligent and read the letters. Make sure that in the letters there isn't contradicting information, because sometimes whenever we are representing our clients, we look through every piece of evidence with a fine-tooth comb and really look at those letters of support. And that we have found sometimes that family members, they really do know this couple. They know this couple is in love. The couple really is in love, but the family member might, unknowingly include a date that's not accurate. So they might put the wrong date for the wedding, or the wrong date that you met, or the wrong date for your trip. You want to be very careful with that, because in inserting contradictory information in the record can be a big issue. So more than font and style, those are some of my main tips for you. And Anna, as always, please feel free to schedule an appointment with me if you are wanting to speak one-on-one about your case. Otherwise, I'm hoping that my responses to you have been helpful, and wishing you the best for your next phase of your immigration journey with removal conditions. So, all right. Watching from Nigeria, great to have you. Carla from the Philippines, that's fantastic. Okay, so you're reading that foreign spouses will get a 2-year green card first and then 10. So actually, as a couple, if you have been married for less than 2 years at the time the green card is rendered, you will receive a conditional 2-year green card. If you've been married for more than 2 years, so for the couples who have to go through a very prolonged immigration journey, by the time you receive your green card, you've been married way more than 2 years, so you'll have a 10-year green card. The 2-year green card, the 2-year conditional green card, is immigration saying, hey, you got married and you went through the immigration process quickly, what immigration would consider quickly, in under 2 years. So we think you have a real relationship. That's why we gave you this conditional card. But we need you to file something called removal of conditions, to have that condition removed from your 2-year green card before we will give you a permanent tenure. They want to check in. So immigration, one of their many, many red flags is, hey, this couple's been married for less than 2 years when the green card was issued. We need to check in with them again and get a lot more relationship evidence of their time together during the 2 years of the green card, and make sure that this couple has a real relationship based on love. And that removal of conditions process is super important. I know there's a lot of people out there that say, oh, it's just one simple form, and you submit evidence. But the reality is immigration is going to be looking very closely at that 2-year green card removal of conditions application. They expect to see a lot of evidence. They're very picky on the evidence, and they look at everything and make sure it tells the story that they want to see, that there aren't red flags, before they will approve your 10-year card. And they can sometimes send you, or rather call you in for another interview. So that's why there are 2 and 10-year cards. Okay. So is it considered late if I file the I-751 after 30 to 40 days from those 90 days required? So you have to file in the 90-day window before the card expires. If the card has expired and you're filing even a day after, it's considered a late filing, and you have to go through a process of explaining to immigration why, and asking for forgiveness. There has to be a logical reason for filing late. And immigration has to believe that reason. So you definitely want to make sure you're filing in that 90-day window before the card expires. What we do for all of our clients is we get started at least 3 months before that window opens, and we prepare to file that application immediately the day after the filing window opens. So we don't have any issues with late filing or extensions of the card. So hopefully that helps answer your question. All right, I'm coming up on time here. I do need to go. These have been really great. Oh my goodness, there's so many questions. um, yeah, Lisa, I thought about you, and I thought about a lot of people that I know are living in Florida. I really hope you stay safe too. Anybody who's in Florida, please stay safe. Take care of yourselves. Take care of each other. Sending you lots of prayers during this difficult time, and hopefully everyone stays safe. All right, these are really great questions. I wish that I could. Yes, praying and hunkering down for sure. All right, so I will go through these questions. You're very welcome, Anna. It's really great to see you. I'm glad that helped ease your mind. Yeah. Okay, good. So yes, you'll file within the 90 days. Perfect. And I'm always happy, like I said, to meet with you in person or on Zoom. All right, everyone. It was great to have you. I will have you with me here today. I'm going to go through these questions I didn't get to, and I can try to start the next live with these questions. Otherwise, please join us. I'll be here with you next Tuesday at 11 a.m. Eastern time, here to answer your questions. It's great to have all of you with us. Please check out the free resource center at immigrationforcouples.com. Have a fantastic week, and everybody, please stay safe if you're in Florida. All right, take care. Bye.